Will the House please come back to order? In accordance with the provisions of Uniform Rule 51, I turn the gavel over to the President of the Senate, the Honorable Gary Stevens.
Thank you, Mr. Speaker. Will the joint session of the Alaska Legislature please come to order? Madam Majority Leader.
Mr. President, I move and ask unanimous consent that the roll call of the Senate be waived and all members shown as present.
Thank you. Without objection, so ordered. Mr. Majority Leader.
Mr. President, I move and ask unanimous consent that the roll call of the House be waived and all members be shown as present.
Thank you. Without objection, so ordered. Will Senator Clayman and Representative Gray please escort Chief Justice Carney into the chamber for this joint session?
Ladies and gentlemen, the Chief Justice of the great state of Alaska, the Honorable Susan Carney.
Good morning, President Stevens, Speaker Edgman, members of the 34th Legislature, guests. I'm pleased, but a bit amazed to find myself here carrying on the long tradition of Chief Justices, updating you on the state of our judiciary. I'm especially happy to speak to you as the Chief Justice of the first majority woman Supreme Court in Alaska's history, and to address the first majority woman House of Representatives. This has been a long time coming, but what an example for Alaska's children, that they can aspire to these kind of positions and know that they can achieve them. Before I get to the details of my talk, let me introduce my colleagues. Justice Dario Borgeson, like me, hails from New England. He came to Alaska in 2008 to clerk for Justice Dan Winfrey in Fairbanks. He was appointed to the Supreme Court in 2020. Among his other duties, he leads the Access to Justice Committee along with Justice Henderson. Justice Jennifer Henderson came to Alaska to clerk for Justice Warren Matthews in 2001. After a brief foray home to Southern California, she saw the error of her ways, and she came back. She served on both the District Court and the Superior Court before she was appointed to the Supreme Court in 2021. And she, along with Justice Borgeson, leads the Access to Justice Committee. She also leads our Judicial Education Committee. Justice Jude Pate was appointed in 2023 after serving 5 years on the Superior Court in Sitka. He lived in Sitka for 30 years before moving way up north here to assume his position on this court. While in Sitka, Justice Pate was an attorney for the Sitka tribe. He was an assistant public defender, and he was in private practice. He leads our committee that provides support and education to our new judges. And finally, Justice Amy Aravik. She is celebrating her 13th day on the court here with you today. She was appointed in December, and she has joined me in Fairbanks. Like all of us, she will soon be tasked with a variety of committee and other assignments, but we've decided to be nice and wait till we leave here and let her know about that. In addition to the members of the court, I'd like to introduce several very valuable members of our court system staff. Stacy Mars is our administrative director. She and her staff oversee all of the on-the-ground operation of all 38 of our court locations. Stacy is recognized nationally for her innovative ideas about improving access to courts. Most of you know our retired General Counsel, Nancy Mead. Nancy has once again agreed to come out of retirement, and we could not be happier to have her back. For many years, Nancy's teammate here in Juneau, as you know, was Doug Wooliver. He has figured out the retirement thing a little more clearly than Nancy has. And so Nancy is now being joined by Noah Klein. He was previously a legislative attorney before he joined Nancy as Assistant General Counsel. Noah continues to live here, and together with Nancy, will ensure that you have a communication channel with the court. In addition to our staff, I'd also like to recognize Suzanne DiPietro, the Executive Director of the Alaska Judicial Council. The Judicial Council was created by the framers of our Constitution to ensure that Alaska state court judges are selected strictly based on merit. This is a system that has served us well, and as we were recently reminded, far better than some. And finally, I want to introduce my family. My husband, Pete Braveman, has retired from 40 years of serving Alaska's family and children throughout the state. With him is our daughter, Rebecca, a proud alumna of West Valley High School. She graduated with a bachelor's degree in culinary arts and is now a chef. Our son, Sam, another proud West Valley High School alum, came to Fairbanks a month ago when I was sworn in by my predecessor. He's listening from apparently very wintry Kansas City this morning. Now let me turn to the state of our judiciary. First, I want to thank the 700 or so employees that work hard every day, along with our trial judges all across the state, to make sure that our courthouses are open and Alaskans have access to the justice that they seek. I am deeply grateful for their commitment. That commitment carried us through the pandemic and continues to maintain our ability to provide the courthouses and the justice that Alaskans seek. The mission of the Alaska court system is to provide access and an impartial forum for the resolution of all cases that come before us, and to decide those cases in accordance with the law, expeditiously and with integrity. You are probably aware that we are not meeting expectations, our own or Alaskans, about the expeditious part of that mission. Several extremely delayed criminal cases have been the topic of recent media reports. The delays in those cases are extraordinary. Criminal cases naturally attract more attention. That's because criminal cases involve real people. They have suffered real injury, and other people are being charged with causing those injuries. We must, and we will, improve how we handle criminal cases to prevent that kind of delay. Let me provide you some context about how criminal cases more typically move through the court system. I do this not to justify those extraordinarily delayed cases, but I do want to provide a bigger picture. The median time between filing a misdemeanor case and closing that case is 4 months for a B misdemeanor. It's 6 months for an A-level misdemeanor. And we have lots of misdemeanors. We closed, 15,000 of them last year. Felonies are the more serious matters. They're more complicated, and they take more time. But for C-level felonies, like vehicle theft, low-level assaults, there's still a median time of 6 months between opening and closing those cases. As the cases become more serious, They become more complex, and they require some more time. But B felonies are resolved typically within 10 months. A felonies, sexual assaults, some serious drug dealing, manslaughter, are typically resolved within 13 months. Unclassified felonies are the most serious cases. They are things like violent sexual assaults, kidnapping, murder. The median time for those cases is 3 years. 3 years is a long time for victims and for other people involved in those cases. But those are the most serious cases. The facts tend to be more complicated. The number of people tend to be larger. The evidence issues that can arise can be very complex, and there's always constitutional concerns. It's very hard to shorten the time that those cases get. We closed 283 of those most serious cases last year. And a handful of them were, as has been reported, terribly delayed. But they're not typical. And I hope that knowing the median times allows you to put those extraordinarily delayed cases in a greater context. I know that the last few justices, chief justices that spoke to you, have explained that criminal cases make up just about a quarter of all of the cases that the court system handles. And of that quarter of the whole caseload, only about 3% of them ever go to trial. The rest of them resolve some other way without a trial. Meanwhile, there's 3/4 of the time and 3/4 of the cases. Those cases that are not criminal cases are therefore civil cases. And civil cases involve matters that are deeply emotional, deeply personal, deeply important to the families and people that bring them to us, like child custody, child protection cases when something has gone terribly wrong in a family, guardianship cases, the probate of wills when someone has died. We know how deeply important these are. And there are also other civil cases that are far less emotional, things like small claims or, whatever it is you think of when someone says lawsuit. Throughout the pandemic and up even now, the court system has handled all of these kinds of cases. We hold trials, we decide issues, and we issue decisions about those things that have been brought to us. We continue to work hard every day, and we've improved our overall efficiency. Even in the midst of the pandemic, in fiscal year 2022, the Superior Court, the courts that handle felonies and family matters, closed over 20,000 cases. Last year, we closed almost 22,000. We're now closing more cases than are being opened. And this matters because it means there are fewer open cases. We've worked hard, and we continue to work hard toward that end. As of last month, we had 1/3 fewer cases open than we did a year ago. And as of last month, we had the lowest number of open criminal cases since 2018. So we are making progress. I hope that this context has given you a little bit more idea of how things typically occur in the court system. But we know that we have more work to do. Reducing the number of open criminal cases and the time it takes to get them done is our #1 priority. At all levels of the court, from all of us on the Supreme Court here today, to trial judges and their staff throughout the state and our administrative staff in support of them, we are working to cut down the number of pending cases. But there's no quick or easy way to do it. This is a multi-pronged problem, and it requires a multi-pronged approach. First and foremost, we are committed to making courtrooms available. If attorneys want trials, we will provide a courtroom. We will find a judge. This isn't new. Previous orders from the Chief Justice, from the presiding judges of all 4 judicial districts, even during the pandemic, invited attorneys to ask us to schedule a trial. But they didn't. Another prong that we are pursuing is education and training. We devoted 1/3 of our annual judicial conference to training on ways to reduce the number of pending cases. The presiding judges in each judicial district have issued orders limiting the number of continuances in a case and limiting the entire time that a case can be delayed, absent truly extraordinary circumstances. And we've authorized overtime pay for courtroom staff and to bring back pro tem judges. Pro tem judges are judges who have retired but are willing to come back to hold trials and work through cases so that we can do more trials than there are judges in a given place. And we continue to look at alternative ways to resolve cases. Because I'm in Fairbanks, I know that Fairbanks has had a restorative justice program for just about 7 years. It is supervised by Professor Jeffrey May at the University of Alaska Fairbanks. Professor May was a magistrate judge for a number of years, responsible for the Galena, Nenana, and Fort Yukon areas before UAF enticed him back. A variety of misdemeanor cases can be referred to this restorative justice program. Last year, they handled 137 cases. Those are cases that didn't have to be handled by the state court. We have also had, and you have always supported, therapeutic courts throughout the state. Those courts address various issues. Some are for individuals whose mental illness has led to criminal problems. Others are for veterans. Still others are for people who abuse substance. These courts require a lot more resources, money and time up front, but they are proven to reduce recidivism. They won't help us immediately reduce the number of pending cases, but they hold great promise for reducing the number of future cases. 2 therapeutic courts are run jointly with tribes. The Kenaitze Tribe and Kenai Superior Court have run the very successful Hinu Wellness Court for nearly 10 years. More recently, the Sitka Tribe and Superior Court have begun holding joint sessions. Collaboration with tribes is another avenue we are exploring. There are tribes throughout the state that have diversion agreements with the Division of Juvenile Justice and also with some district attorneys' offices. Those types of agreements hold real promise for young offenders. Instead of having a court date sometime in the future, often in a community far away, the offender deals with the tribal court, the tribal council, or another community group to address the harm that was caused more quickly and where it was caused. And in court, Criminal Rule 11 allows communities to hold circle sentencings or other types of gatherings so that the community can make a recommendation on what it thinks is the appropriate sentence for an offender from that community. These are some of the ways that we are approaching criminal cases. But we can only do so much. We provide the place, the courtroom for the trials. But lawyers, prosecutors, and defense attorneys have to try the cases. And if the defendants are in custody, the Department of Corrections has to make them available to be brought to court. And then the Department of Public Safety, our judicial services officers and the state troopers have to bring them to court. Just about all of those people work for the state. And as you know, state agencies continue to have trouble filling all of their positions. All of this has focused on criminal cases, but we're also looking at alternative ways to handle all the other cases, the 3/4 of other cases that come through our justice system. Technology is an important part of this. All across Alaska, Alaskans can make an old-fashioned phone call. They can browse a website. They can use an online platform to get essential information to help them resolve whatever their civil dispute is. We have self-help and access to justice departments that provide a variety of online resources in just about every kind of civil case. These can range from helping to come up with a parenting plan when parents need to figure out child custody, figuring out how to file a small claims action, or navigating the complicated and emotional journey of probating an estate when a loved one has died. There are 1,500 forms written in plain language that can be filled out without a lawyer to help. And people can call the Self-Help Center and talk to a trained person who will give them procedural information about how to file things in court, or direct them to forms for things like custody, guardianship. We have an early resolution program in all states now, in all courts statewide now. This program involves about 2/3 of all the divorce and custody cases that are filed by people without lawyers. They participate in an expedited process, often doing it by video. They use volunteer attorneys, mediators, and a settlement judge to help them quickly resolve these cases, which will benefit their family into the future. About 80% of these cases resolve within a matter of weeks rather than months, and they usually get the final orders controlling the custody after just a single hearing. In the past year, we've launched a totally online dispute resolution platform to resolve debts. This forum allows parties to negotiate their disputes or work with a mediator without needing to come to the courthouse or even see the person that they're disputing with. There was a 3-month-long negotiation recently that resolved a fairly long-standing dispute between a fisherman and a processor. And we're soon going to use grant funds to launch a cutting-edge chatbot on our website. It will use generative AI, and it will help people navigate that complicated process of dealing with an estate when they've lost a loved one. We continue to offer mediation in child in need of aid cases. This allows parents, the state, and tribes, if they're involved, to try to reach an agreement without going through a lengthy and painful trial. And we are working with tribes to make it easier for them to intervene in these cases or take jurisdiction in cases that involve tribal children. We're also working with tribes to make sure that tribal domestic violence protection orders are quickly registered in state court so that they will be enforced just the same as those protective orders that originated in the state court. We are grateful that you have funded 4 monitor positions to help family guardians, relatives, friends, loved ones who are not professionally trained guardians to serve as guardian for people. These monitors help people figure out how to do that job and also help them to go through the required reporting that courts need every year to ensure that these guardianships are actually caring for vulnerable people. Now let me turn to our request for funds. This year, our operating budget is truly just a maintenance budget. We are asking for funds only for the things that we know have increased. Things like increased payments on leases because the landlord raised the rent. Costs to keep our court visitors in guardianship cases. As our population ages, the number of guardianships go up. Costs to keep the therapeutic court staff that we've had so that they can continue to intervene in these very useful and successful courts. The Supreme Court's capital budget, however, is more substantial. Our most basic obligation is to provide the place, the courtroom, where cases can be addressed. And we are asking you to support that, to allow us to fill that obligation by providing funds for more courtrooms in Palmer. Noah Klein and Nancy Mead will provide you more details about this in the coming weeks. But we all know that the Mat-Su area is the fastest growing population in the state. The Palmer Courthouse already doesn't have enough room for the judges who are there. Palmer Superior Court judges have the highest per-judge caseload of any judges in the state. We need more judges to serve the Mat-Su, but we need a place to put them. Last year, Chief Justice Mawson and before him, Chief Justice Winfrey each explained this same situation. And last year, you provided the funding for phase 1 of this project. We are now in the process of using those funds that we are so grateful for to do the final architectural design work and permitting so that we can add 3 more courtrooms, as well as space for the judges and the staff that will use them. We're hoping to break ground for utilities just as soon as breaking ground becomes possible. What we're asking for now is phase 2 funding to actually do the constructing. I know that you have many competing requests for funds, and I know you have to balance what everybody needs and wants against fiscal reality. I do not envy you that job. But I do want to stress that the Palmer Courthouse is our #1 capital priority this year. And I hope that you will very seriously consider this request. Closer to here, we also need to do something about the courthouse in Sitka. The courthouse is in a building with very complicated ownership, and that has made it a real challenge to address deferred maintenance, things like a new roof, mechanical upgrades. We've had some additional issues recently that forced us to close the court for a number of days. Our staff has really soldiered on admirably, but we need a long-term solution. And we appreciate very much your efforts last year to try and help us buy a building. But for now, we will continue to explore options to see if we can find an adequate facility in Sitka. Far from Sitka, we are continuing to work with executive branch agencies, the Bethel Native Corporation, and the Lower Kuskokwim School District to finalize a plan for a Bethel Justice Center. That center would house all the agencies that regularly come to court, along with us in the same building, so that people out in the YK Delta would have basically one-stop shopping. And I'm not asking you for money. Instead, we are exploring different funding options to make this a reality, and I hope to be able to report back to you what we have accomplished. Our courthouses throughout Alaska need security. We've been fortunate this far. We have not suffered any of the terrifying violence that has been directed against judges and court staff outside. But we still need to prioritize security. In the wake of the cyber attack a few years ago that took us completely offline for weeks, you generously funded a pretty expansive program to increase our cybersecurity. We're deeply grateful for that, and we continue to try to be constantly vigilant on that front. In addition to improving our technology, we also need to improve more basic materials, things like courthouse doors, the counters in clerks' offices, our courtrooms, so that we know when people come into our buildings to resolve their differences, that they will be safe. I hope that you will find room in the budget to fund that for us. Finally, on behalf of the hundreds of Alaska court employees all throughout Alaska, I want to thank you again for inviting me, for taking time out of your very busy days, and for listening to me. Thank you. Thank you very much.
Thank you, Chief Justice. Madam Majority Leader.
Mr. President, I move the adjournment of the joint session.
Without objection, the joint session is adjourned.
The House will stand at ease.